Blake Lively requested the withdrawal without prejudice of two of her claims relating to the infliction of emotional distress. Against It Ends With Us director co-star Justin Baldoni. Despite the Gossip Girl alumna dropping those claims, Lively can still introduce evidence of emotional damages via other claims, excluding medical records. The actress continues to allege emotional distress as part of numerous other claims in her lawsuit, such as sexual harassment and retaliation, and massive additional compensatory damages on all of her claims, according to her legal team. Despite Blake Lively recently dropping claims against Justin Baldoni of inflicting emotional distress, the actress still has a route to pursue those accusations moving forward. Amid the actress' ongoing legal battle with her It Ends With Us director co-star, Lively, 37, requested on Tuesday, June 2, to withdraw and dismiss her claims of intentional infliction of emotional distress and negligent infliction of emotional distress. The move came after Kevin Fritz, a lawyer for Baldoni, 41, filed a letter addressed to Judge Louis J. Lehman in U.S. District Court, Southern District of New York, requesting an order compelling Blake Lively to identify her medical and mental health care providers by signing a HIPAA release for access to therapy notes and relevant medical information. The document noted that instead of complying, Lively requested to withdraw claims of emotional distress without prejudice. Doing so, the letter alleges, means that Lively refuses to disclose the information and documents needed to disprove that she suffered any emotional distress and seeks to maintain the right to refile her infliction of emotional distress claims at an unknown time in this or some other court after the discovery window has closed. Ms. Lively cannot have it both ways. On Wednesday, June 11, Judge Lehman clarified via a ruling that if the claims are not dismissed, the court will preclude Lively from offering any evidence of emotional distress. The court did not bar Lively's team from offering evidence of other emotional distress, per the ruling. We are pleased that the court confirmed today that Ms. Lively can, in fact, present evidence and testimony of her emotional distress, which she intends to do, Lively's lawyers, Ezra Hudson and Mike Gottlieb, said in a statement on June 11. Her decision to dismiss her specific causes of action for emotional distress does not bar her from presenting this evidence because emotional distress is an element of many of her remaining claims. The court made that clear today. Following the Another Simple Favor star's legal team withdrawing two of her claims relating to the infliction of emotional distress, Hudson and Gottlieb responded in a statement shared with People. Once again, this is a routine part of the litigation process that is being used as a press stunt. We are doing what trial lawyers do, preparing our case for trial by streamlining and focusing it. They are doing what they do, desperately seeking another tired round of tabloid coverage. Lively continues to allege emotional distress as part of numerous other claims in her lawsuit, such as sexual harassment and retaliation, and massive additional compensatory damages on all of her claims. The co-star's conflict began last December when Lively filed a sexual harassment complaint against Baldoni, alleging misconduct on the Colleen Hoover adaptations set in a retaliatory smear campaign, which he has denied. In the original filing, Lively alleged that due to Baldoni's behavior during and after the filming of It Ends With Us, the emotional impact on her has been extreme, not only affecting her, but her family, including her husband and 4 children. The Jane the Virgin alum countersued Lively, her husband Ryan Reynolds, and their publicists in January for $400 million, alleging extortion, defamation, and more. However, the countersuit was dismissed on Monday, June 9, along with Baldoni's $250 million defamation lawsuit against the New York Times. Lively and Baldoni's trial, during which both are expected to testify, is currently scheduled for March 2026.